Welcome back to the Deep Dive. Today we're diving into a crisis that is, well, often completely invisible until it's way too late.
Yeah.
We're talking about the huge health and legal risks that get created when landlords, decide to do renovations or repairs in older buildings without following basic lead safety rules.
It's such a critical topic because I think most people's knowledge sort of stops at disclosure. Did my landlord tell me there might be lead paint?
Right.
But what we're looking at today is something so much more dangerous. We're talking about the active disturbance of that paint, usually in a pre-1978 building, which just instantly creates this toxic lead dust problem.
That distinction is everything, isn't it? I mean, most tenants in an old building assume there's probably stable lead paint somewhere, under layers of new paint. It's just sitting there.
Harmlessly.
Exactly. The danger we're really examining is the act of disturbing it. The sanding, the scraping, the cutting, that's what turns an inert thing on a wall into a toxic cloud you can breathe.
And it happens fast. Our mission today is really to give you the tools to understand that process, to see the layers of laws, both federal and state, that get broken when this happens, and what you can actually do about it. We're moving from just being aware of a problem to, well, enforcing accountability.
Okay, let's unpack this. So we should probably start with the baseline, which is if lead paint is intact, stable, not flaking or chipping, it's a relatively low risk. It's kind of a sleeping giant.
A sleeping giant is a perfect way to put it. The trouble starts the moment the construction crew shows up. That's when it wakes up.
And the sources are clear. This transformation from stable to dangerous is immediate. When you scrape or sand or cut any surface with lead paint, you're basically grinding a toxic material into microscopic dust.
And the scary part is how that dust travels. The sources point to three main ways this makes a home toxic. First is just airborne dust.
So like if you cut through an old window frame.
Exactly. That sanding or cutting action, it doesn't just make little chicks. It atomizes the lead into these invisible particles that just drift through the entire home. They don't stop at the door of the work zone.
Which leads right to the second hazard, surface contamination.
Yes.
Because those particles have to land somewhere.
And they land everywhere. We mean every single flat surface. Your countertops, your floors, inside your kitchen cabinets, on your dishes, your kids' toys. It's this fine, gritty residue on everything you own and touch.
And then the third problem, which is maybe the most insidious, is its long-term persistence.
Right. People think, oh, I'll just, vacuum it up. But a regular vacuum? That just makes it worse.
How so?
A normal vacuum cleaner basically acts like a fan for microscopic lead. It just blows the tiniest, most dangerous particles right back into the air. So without a very specific, specialized cleanup, that lead dust stays in the home.
Indefinitely, like long after the workers have packed up and gone.
Indefinitely. And that's why kids are so incredibly vulnerable. They're on the floor, they're touching everything. And then there's the hand-to-mouth behavior. They're literally ingesting the dust.
They don't even need to eat a paint chip.
Not at all. They just need to play on a contaminated floor. But, we have to stress, adults are at risk too, especially if it's a big renovation that creates a lot of contamination.
So given this hazard, let's talk about the laws that are supposed to prevent this exact scenario. Because when a landlord authorizes unsafe work, they're not just breaking one rule.
Oh, no. They are violating multiple overlapping federal and state laws, often all at the same time.
Okay, so what's the big one at the federal level?
The baseline for protection across the whole country is the EPA's Renovation, Repair, and Painting Rule. Most people just call it the RRP rule.
And that applies to any paid renovation work in a pre-1978 building.
Almost any, yes. And it is very, very specific about how that work has to be done. The sources lay out these non-negotiables. First, the contractors themselves must be EPA certified.
So you can ask to see their certification.
You can, and they have to show it to you. The rules also say work areas must be contained with heavy plastic sheeting. You have to seal off the area, and warning signs have to be posted.
But the real teeth are in the things they can't do.
Absolutely. The equipment and the prohibited practices. So, for example, if you see a contractor using a regular shop vac or a household vacuum cleaner, that is a massive federal violation, full stop.
Wow. So they need a special kind of vacuum.
They need what's called a HEPA vacuum, high-efficiency particulate air. It's designed specifically to capture those tiny lead particles without just blowing them back out into the room.
So wait, just to be clear, if I see a guy in my apartment using a regular vacuum to clean up paint dust, that one act alone is a serious legal violation.
A serious violation with potentially massive fines attached to it, yes. because they are actively spreading the hazard.
What else is banned?
The RRP rule specifically prohibits things like open flame burning to remove paint or using a heat gun above 1100 degrees Fahrenheit.
Why the heat gun rule?
Because that extreme heat doesn't just peel the paint, it actually vaporizes the lead. It creates this invisible, toxic fume that's incredibly easy to breathe in. It just turns a bad situation into a disaster.
And that's just the federal floor. Many states have even stricter laws on top of that.
Exactly. The source material uses Massachusetts as an example, which has its own lead law. And these state laws often require things like mandatory notification to tenants before the work even starts.
Giving you a chance to prepare or, get out of the way.
Right. So since you're not going to have the rule book handy, what are the practical red flags you should look for?
Yeah, what tells you a violation is happening right now?
During the work, the biggest one is just no containment. If you see dust being cracked all over the building, or if they're scraping paint without sealing off the room with plastic, that's a huge red flag.
Or no warning sign.
No warning signs, or if the crew can't show you their EPA certification, and then after the work is done, the signs are physical.
Like that fine, gritty dust we talked about.
Exactly. If you find that dust on surfaces outside the work area, or you see visible paint chips left on the floor, that tells you they skipped the required specialized cleanup. The job isn't done right.
And this is so much more than just a compliance issue. We really need to pull back and talk about the health impact here. This is the gravity check.
For children, it's just devastating. Their nervous systems are developing so fast. Even a brief exposure from one sloppy renovation can cause these long-term irreversible
We're
problems.
talking about things like developmental delays.
Developmental delays, a measurable drop in IQ, behavioral problems, hearing issues. The damage is often permanent.
And for pregnant women living in the apartment.
The risks are just as severe. An increased risk of miscarriage, premature birth, and it can cause developmental problems for the baby before it's even born.
And we have to keep saying it. Adults are not immune. A really bad renovation can lead to serious issues in adults.
Yeah, we see things like cardiovascular problems, basically high blood pressure, and even kidney damage. Neurologically, it can look like memory problems, trouble concentrating, that kind of brain fog that just won't go away. And even if you don't have kids living with you. Right. If your niece or your nephew or grandchild comes over to visit and plays on that contaminated floor, they are at risk.
Here's where it gets really interesting, because the law sees how severe this threat is. And it gives tenants some serious power.
It does. The legal consequences for a landlord who does this are layered, and they are severe. Let's start with the EPA.
The federal hammer.
Right. A violation of that RRP rule we talked about can carry civil penalties of up to $44,539.
Wait, per violation?
Per violation per day.
Per day. So a week-long bad renovation could lead to hundreds of thousands of dollars in fines.
It absolutely could. The financial risk for the landlord is staggering. It makes cutting corners just seem absurd.
And that's before you even get to state laws.
Exactly. At the state level, you have consumer protection laws. When a landlord knowingly exposes you to this, that's often considered an unfair or deceptive act.
And it also violates just basic tenant rights, right? Like
Yeah.
the warranty of habitability.
Of course, a landlord is guaranteeing you a safe, livable home. Poisoning it with lead dust is a profound breach of that guarantee. It's such a severe breach, it can be what's called a constructive eviction.
Meaning the place is so uninhabitable, you're basically forced out.
And you're entitled to damages, including getting all your rent back for the time it was contaminated.
But there's one legal standard that's even more powerful, especially when a child is hurt. The sources really highlight this precedent. Bencosme v. Kokoris.
That case changed everything for tenants. The court basically said that for lead poisoning injuries to a child under 6, the landlord is strictly liable.
Strictly liable. What does that mean in simple terms?
It means you don't have to prove the landlord was negligent or, knew how dangerous it was. The simple fact that they failed to follow the safety laws and a child got hurt as a result, that's enough. The failure is the proof.
That's a huge shift in power.
It's the most powerful legal tool available. It removes that burden of proving what the landlord was thinking. The action itself is what matters.
And when do courts bring down the heaviest penalties?
When it goes beyond just being careless and becomes what the courts call affirmative deceptive conduct, there's a pattern they look for.
Which is?
The landlord has documents showing there's lead, but they hide them from the tenant. Then they authorize the unsafe work anyway. And when the tenant complains about the dust, They give these false assurances like, oh, don't worry, it's fine.
That cover-up is what really maximizes their liability.
It turns a bad situation into a legal and financial catastrophe for them. And one last point, landlords can't use the presence of lead as an excuse not to rent to a family with kids.
So they can't say, oh, there's lead here, so I can't have your kids living here.
Nope. That's illegal housing discrimination under federal and state law. Their duty is to make the property safe, not to discriminate.
So knowing all this is a form of protection. But if you think you've been exposed, what are the immediate actionable steps you need to take?
Okay, step one is health, immediately. Don't wait for symptoms. Get blood lead tests for everyone in the household. Kids, adults, even frequent young visitors. Talk to a doctor. Document everything.
And while you're doing that, you have to minimize any more exposure from the dust that's still there.
Yes. The sources stress this. Wet mop your floors. Use disposable cloths. Never, ever dry sweep or use a regular vacuum. You'll just kick the dust back into the air.
And if it's really bad, you might have to leave temporarily.
You have to consider it, yes, until you can get the place professionally tested and certified as clean.
Okay, step 2, documentation. You have to gather evidence before it disappears.
And you have to be fast. Take photos and videos of everything. The lack of plastic containment, the dust on your furniture, contractors working without protective gear.
And save every text, every email.
Every single written communication where the landlord talked about the work or told you it was safe. But the most critical piece of evidence is from an expert.
You mean proving the lead is actually there?
Yes. You need to call your local board of health for an inspection or hire a licensed risk assessor to take professional dust wipe samples. Those lab results are the hard proof you need for a legal case.
So finally, let's talk about damages. If the violations and the exposure are proven, what can a tenant recover?
The damages are meant to be comprehensive, so on the economic side, it's everything. The cost of medical testing and treatment, getting your rent back, moving costs if you had to leave.
What about your personal property? If your couch and your clothes are all covered in lead dust?
Compensation for that, too. For ruined furniture, clothing, anything that was contaminated.
And then there are the enhanced damages, the legal hammer.
That's right. For those willful or knowing violations, like the landlord hiding documents, consumer protection laws allow for treble damages.
Triple damage?
Triple.
Yeah.
So if your economic damages were, say, $10,000, a court can legally turn that into a $30,000 award. On top of that, the landlord is almost always forced to pay all of your attorney's fees and court costs.
So what does this all mean?
It means that a landlord who cuts corners on lead safety isn't just being cheap. They are actively breaking serious laws and putting their tenants' health at severe long-term risk. And because it's so serious, the law provides for these massive, sometimes tripled damages. The system recognizes this is an unacceptable breach of safety.
And the final provocative thought we want to leave you with is this. The cost of doing a renovation the right way with a certified safe contractor is a tiny fraction of the fines and the legal judgments a landlord faces if they get caught doing it wrong.
That knowledge completely shifts the power dynamic. You don't have to wait until someone is sick. Your knowledge and your ability to quickly document what's happening, that is your protection. Document everything, get tested, and understand that the law is built to protect you from this exact kind of hazard.